Well, hello folks, and welcome to yet a special edition of Smarter Money Matters. It really does. We have the special guest, of course, of your wealth, Dr. Jeff Camarda, along with Super CFP, Anna Wunderlich, and my good friend and top shelf lawyer, Jason Porter, is here to give us some deep insight on managing potential divorce situations to maintain wealth in the family and present the lowest amount of disruption possible.
Rule number one is don't get divorced, Jeff.
So I guess, you probably have some kind of a checklist or an algorithm. What would you say the first rule of divorce is?
Aside from not getting divorced, right? The first is to have a good handle on your assets.
Yeah.
You need to know what you have, where it is. You need current valuations for whatever the particular investment might be. It's good to have everything in some sort of paper or digital format so that when you go in to have that initial consultation, you can say to the lawyer, this is what we have.
So these are folks that kind of on the doorstep of divorce and they're in the legal consultative process, and you want to make sure that you're well informed so assets kind of don't disappear. Is that right?
Absolutely. And your lawyer can only help you as much as to the degree that they have information, right? If something's left out, then it's left out for the lawyer too.
So what's a typical checklist? Say that, God forbid, Anna darkens your door, with a tale of woe to tell. What questions would you be asking her about, what her asset structure is to make sure nothing is missed?
I would say, Anna, first tell me about your real property. Do you own your home? Do you have investment properties? Anything that is land-based, that's real property. We need to know about that to start, okay? Then I would want to know how much cash do you have on hand? What's in your checking account? What's in your savings account? What's in your retirement accounts? What types of retirement accounts do you have? I want to know about the investment account. I want to know everywhere that Anna's investments are, because as you know, folks have investments all over the place. And especially if we're talking about a gray divorce, which is the long-term marriage, assets have accumulated over time.
You notice he was looking at me when he said that.
People have changed employers. Sometimes that means their retirement money's over here in the past. There's a new retirement account, those types of things. And all of those things have to be accounted for. To some degree, personal property can play into the equation.
You mean like cars and motorcycles and lawn tools, jewelry, that
I'm
kind of
thinking
stuff?
more like when Anna talks about jewelry, that's kind of what I had in mind, because some of that, I would think some things are more valuable than others.
Thinking you had it right.
Right. So some things are more valuable than others. Some things that are personal property will appreciate, whereas some things, cars, they're not appreciating, those types of things. Typically.
Good point. So I guess what about husband's property? Let's delve, because that's a bit of a gray area. So I'm guessing, and when you say real property, obviously you mean real estate, houses, rentals, land, that kind of stuff. So say that Anna and her husband bought a house or an investment property, but for convenience, the husband closed and it's just in his name. But they bought it after they got married. What about that?
Anything that is purchased during the marriage, except for limited circumstances, is going to be considered marital property.
Whether her name is on it or not.
Correct. Whether her name is on it
Well, that's
or
a
not.
conflict.
And now there are some limited circumstances, and let me explain one of those. Let's say that the husband has a trust that was left to him by a parent or a grandparent, and he takes money from that trust that he never commingled with the marital finances, and the money flows from that trust into that piece of property in his name, then that's going to be where the lawyer makes his or her money, because that is going to be a question of law, and it's going to be heavily litigated.
So let me make sure I'm following you. So for the sake of what I said, I'm the husband, and I have a trust, and I get some money, and then I take it out of the trust, right, and buy a piece of property. If I put it just in my name, am I still protected?
You are. I would say maybe.
And if I put it in joint names, then what happens?
Okay, so if it's in the joint name, Jeff, then at that point it's commingled. Okay, so then it's clear that Anna has a claim to it. If it's not commingled and the property is only in the husband's name, then at that point the husband's going to say, it's mine, it was never commingled. Anna's going to say, well, we were married and it's still half mine, and that's going to be an issue that gets litigated.
But if she's, if she's being Machiavellian, on the purchase, say, well, honey, I could take care of the bills and everything else and sign for it, so why don't you put it in both names? And at that instant, half of it's hers, right?
Correct.
Important planning point from all perspectives. That's something not to lose sight of, guys. It really, really is.
And the key language is commingled. That's the language that the law uses when it looks at marital finances. Anything that is that predates the marriage and is not mixed in or commingled is typically outside of the divorce proceedings.
Right. So that if I'm, bright boy that I'd like to be, if I say, you know what, I think I better buy that land in the trust, whether I'm the trustee or not, does that give me more protection?
Absolutely. Absolutely.
And for a lot of our clients out there that are thinking about maybe protecting their kids as part of their estate planning, these are really important considerations. So we're trying to, share them in an amusing fashion somewhat, but these are important things to think about, which is why, we tell you very often, one of the big reasons to set up a trust and a continuing trust for your kids, and I'll say Anna's my daughter, when the money is in a trust, and maybe she's the trustee of that trust, and I'll say, Anna, you want to make sure you keep this as yours, you keep it in a trust. And then when husband argues that, gee whiz, if you love me, you'd put my name on it so I can pay the bills. And I said, well, honey, you know I do. But you know what a son of a gun my daddy was? I can't. It's in the trust. And it gives her plausible deniability to protect her interest.
Absolutely. 100%.
So what are some of the other, considerations or planning points that you have? And I'm sure you have some questions as we go through this, but what other things do you counsel folks that maybe are looking to maximize their share of the distribution of marital assets? She comes in with a box, full of deeds and whatever.
Statements.
Well, I understand the question. The answer is not as straightforward. The starting point is to maximize any take from a divorce. Ultimately, it's about the protection that started on the front end before you went into the divorce. So, you've talked about trusts. We think about prenuptial agreements, right? Now, ultimately, when you talk about a young couple that's getting married, oftentimes they don't have anything that they see as valuable enough to protect with a premarital agreement.
Sure.
Certainly, we understand that. But when we talk about later in life marriages, then...
Can I just make a sidebar comment on that? However, if there may be an asymmetric earning capacity between a young couple, maybe the spouse who may have a partnership or an ownership interest, and the other person works for a salary and might make a couple $100,000 a year, but probably not millions. Right. That's probably a consideration we're thinking about, is it not?
Yeah, I agree with that. Again, I guess that just depends on age, status at the time of marriage, those sorts of things. But that inequity in income potential could be addressed through a prenuptial agreement. I agree.
So sorry to interrupt you.
That's okay.
So we're talking about more getting back into the gray zone here.
Right. So you asked me about how do you protect the...
I felt the chill in the back of my neck.
Well, you said how do we protect as much as possible. Trusts prior to marriage, prenuptial agreements, those are two primary vehicles for the protection that you're talking about. When we get into the post wedding phase, right, and the marriage is building over a number of years, at that point, there's a presumption, at least under Florida law, which is the state that we sit in right now, and I would say under most states as of 2026.
Non-community property states.
Correct. Correct. Most states now have a presumption that all marital property is to be divided 50-50. There are offsets. There are reasons that courts may say one spouse deserves more than another. But when you come into my arena, The honest answer would be, I can't tell you on day one what that inequitable distribution might look like. I can tell you that
But the presumption is equal.
The presumption is equal as a starting point. And there are circumstances that could lead a court to give an inequitable. And sometimes it's as simple as horse trading, right? Maybe, let's say the husband was the primary income earner, right? And the husband contributed to a retirement account at the maximum level. And he's 10 or 15 years out from retirement, and the couple has a house, and maybe the house has got significant equity. Well, the husband may say, listen, that retirement account is worth a lot more to me in the long run than the house is in the short run. And that may lead the parties to agree to an inequitable distribution, or ultimately, if this were to be litigated, it may lead the judge to say, well, I'm going to do this inequitable division, but it's still fair under the guise that the cash now is money up front, right? Present value of money versus for the husband, he's not getting cash up front because it still resides in the retirement account, but he's got it down the road.
Sure. So to soundbite that though, there's a lot of potential area for disagreements and expensive litigation that could happen in a lot of cases that might be best blunted with prenuptial or trust planning.
Absolutely.
So let me seg a little bit now. You find it's always been my belief that using trusts for this purpose are far more palatable than prenups. Prenups just have a kind of a distasteful onus to a lot of people. Did you agree, or
well,
or they're not comprehensive as comprehensive as prenups?
Well,
it's really just existing assets. Right?
What I would say is this: for those people who think ahead and have the resources and the understanding to establish trust prior to marriage, that gives an added, very thorough layer of protection. However, trusts don't address all of the issues that could come up in the course of a marriage, right? So the prenuptial agreement could be the fine-tuning of anything that perhaps isn't dealt with in the trust. So the answer is
an added layer.
It's a multi-layer of protection, and that's the way it should be addressed.
Good. And I'm sure that you've been thinking about a lot of questions as you often do. Tell us, what some of
Yeah. So Jason, I'm a little curious. If there's minor children involved, if a client comes to you, a wife, there's a divorce potential, and they have minor children. What are some considerations, that you guys might ask about or be thinking about in that situation?
Well, when we talk about minor children, the first thing that comes to mind in any divorce is where the children going to live. We used to talk about this as custody. Florida law does not use the term custody anymore. It refers to it as time sharing. And there is a presumption that time sharing is 50-50.
Okay.
So the idea that the children shall reside with the mother the majority of the time is now considered antiquated.
Okay.
And that's attached to the caretaking role of the wife, right, of the mother. But that's considered antiquated, and now Florida law, to sort of recognize the old view versus the new view, uses the language timeshare.
Okay.
So there's a presumption of 50-50 timesharing. That's the first issue that any couple with young children in the midst of divorce are going to think about.
What about support issues? There's a lot of slime balls in Florida, and mom getting paid is often somewhat of a challenge, right?
Yes.
Well, there is that, to be sure. However, when we talk about the time-sharing split, if it's a 50-50 split, then it's 50% support from each parent. So you can see how those levers go up and down, right? If I've got 20% time-sharing, then I'm only covering the percentage of support, right?
Sure.
And let me be clear. So if it's 50-50, and then the levers tilt to 80-20, then if the child is with the father 20% of the time, then he's paying 80% support to the mother, right? Because he gets credit for the 20% he's got the child, right? So that comes into play.
Which gives the mother a significant incentive to, you know, to keep that child home.
Sure.
Exactly.
Sure.
Exactly.
And I'm sure that there's a lot of, you know, how enforceable is it? Say that, you know, say that I've got the kid 20%, but I want to pay the 30%. You know, how do you chase them for the other 50? How do you get the money now?
Well, yeah, the courts have things called, we would refer to that as a motion for contempt, motion for enforcement, and we would
But how collectible is it, though? I mean, you hear a lot of horror stories
well,
about delinquent dads.
sure, there's no question about that. It really comes down to the judge that presides over the case. Some judges are more aggressive about enforcing those things than others. My experience has been that most judges will consider a matter and perhaps, you know, if we have a delinquent dad, have the delinquent dad in front of them and say, listen, this is your one bite at the apple, right? You make it right and all is forgiven. But if you don't make it right, then you go to jail. And that's the end result of any motion for contempt.
There's an old saying that a good lawyer knows the law, but a great lawyer knows the judge.
Not sure if it's ethical or not for me to say that's
Yes,
correct,
no
but
comment.
I'll say this.
That's
It's not wrong.
So, and what about, I guess, finding delinquent dads, or, you know, in terms of the sport issue? Is that something that, you know, is?
So
I guess it's, you know, husband underwriting and picking the right guy.
Well,
that really is
yeah.
an important consideration, right?
So let me say this. I think that as much probably like your practice has evolved over the years, my practice has evolved over the years. And so clients and their needs change as the lawyer's experience grows, right? But certainly on the level where there are delinquent dads and they're trying to hide and stay out of view to keep whatever money they may have, there are folks that I would employ, and I'm sure other lawyers who do my type of work would employ, to find the people wherever they may be and make things happen.
So you also then now it depends. A good lawyer knows a good PI. Right?
Absolutely.
What about, you know, you have another question? Yeah, I'm sorry.
Oh no.
You did. I always talk too much.
No, I did have, I guess, a question. You know, let's say you work with a client, divorce goes through. After that, what are some things that you think they should consider after that process is done, maybe?
There are lots of things to consider once the process is complete. Number one of which is, am I ever going to get married again, right?
Yes.
But beyond that, I think really a thoughtful look back over what has happened, right? Why am I looking back at age 50 on a marriage that ran 25
Sure.
years, and here I sit divorced? I think that's worthy of introspection. Beyond that, when we talk about assets and what the future looks like, then absolutely no question, if there are assets to be protected, now is the time to protect them, right? And if at some point there is another marriage on the horizon, then before that advances, there needs to be a consultation with an experienced divorce lawyer to talk about what a thorough, we would say bulletproof prenuptial agreement looks like.
Yes.
Right?
Yeah.
And so those are the sorts of things that come to mind.
Thank you. Yeah.
Do you find the onus of a prenup, particularly, you know, for, you know, mid-career and older folks, is lessened at all over the years as the country's become more sophisticated with wealth planning, or is it still, you know, a big bugaboo?
You know,
Particularly for living.
I would say this, Jeff. I agree with you that as financial planning has become more sophisticated, perhaps it is not as necessary, but I would never move into that second marriage
I think it's 100%
without
necessary,
having
but
it,
you
right?
find that it's still, you know, it's a point of friction, you know.
Or more palatable, maybe.
Yeah.
Still
kind of peas on
maybe
the
I
romance.
missed it. Yeah, I don't think it dampens the romance as much as it used to. I think at this point the level of sophistication, especially among people who would actually need it, right, that have something to protect, I think everybody goes in saying, okay, this is part of life at this point.
And it's something that that your clients, because and I hope that you'll share this with them, might want to consider is, say that you have a second marriage, both spouses bring assets to the table, it sticks and they're happy. When they do estate planning, there's still a real bias toward just putting the current spouse, and one of these yesterday, as he had one kid, she had two, but she is his beneficiary. He's probably going to die first, being a guy, right, with being on a mortality table. So it could happen the other way.
Right.
He could die first, and he's her beneficiary. But they each have kids from previous marriage, and I'll call them, John and Betty. And I say, Betty, if if he dies first, or if you die first, that money goes to John. And it's all his. Even though you have a trust and a will that says it's to be divided, if your kids get some of the money. And John doesn't have to do that. It's all his because he's the beneficiary. Right. So a lot of folks kind of don't think past that when there are kids from previous marriages, the subsequent, levels. And it's so important to maintaining the wealth, in the direction that they care about.
Right. Yeah. And ultimately that, my firm, because of the clients that we represent, we have a more than a passing familiarity with estate plans and things of that sort. But it's not specifically what we do. However, we do have to field those types of questions and those considerations. And what I would say to anybody who's watching us who has those concerns, what's most important is that you figure out what you want to do. Because the law, a good lawyer who drafts a proper agreement can script out exactly what you want to happen. So the most important thing is that you know exactly what you want to happen. And I would suggest that you talk about it with the stakeholders, right? John doesn't want Betty not to know what he plans to do, because that's friction waiting to happen, right? But I think rule number one is know what you want to happen, and then seek counsel from a lawyer who can put it in writing so that it's executed in accordance with your wishes.
Excellent. So as we approach the half hour mark, do you have any other questions?
I don't think so.
And one last thing is, alimony, which has really changed so much over the years. What's going on these days with alimony in Florida? It used to be lifetime, by default, but really that's not the case anymore.
There's no such thing as lifetime alimony. Now we have what is known as durational alimony, right? And it's prescribed according to a formula that's set out in the Florida statutes. And it's, you can sort of just do the math and it will tell you. Long-term marriages do still have the potential for long-term durational alimony, but it is not what it used to be. And there is a prescription in terms of what the amount is, and it's roughly 30% of the difference in net income between the parties. And it's some slight difference from what I just said, but it's in that ballpark. And again,
the duration is often a function of the length of the marriage.
It is always the function of length of the marriage.
And then before we go, we probably should talk about Social Security, quadros, and that kind of stuff. So, right?
Right.
Would you care to share, or you want to ask any question?
Well, you certainly can ask me a question, but essentially, if there's any sort of retirement split, then in most circumstances, it's going to call for a qualified domestic relations order, which is a quadro. It's particularly relevant when there are military retirements at stake. We see that most often.
Right. So, and then basically what that does is orders half of the retirement assets, I think, right? If there's a pension, or if there's IRAs or 401ks and that kind of stuff.
Sure.
And is that default pretty much 50-50 between the parties, or is that negotiable?
It is pretty much 50-50, though it can be negotiable. And what it does, back to that example I was saying, that inequitable distribution, sometimes retirement would be split a certain percentage in exchange for other assets up front being split. But you are correct. And what that the quadro, qualified domestic relations order, is it sets forth for the plan administrator exactly how the retirement assets are going to go.
That's very helpful. Any comments on Social Security? that's kind of a free pass, right? I think you get, if you're married long enough, the spouse gets Social Security with
Can claim against it.
no diminution, I think, of the earners. So
Agreed.
it's pretty cool.
Agreed.
Yep. Well, that was fantastic.
Well,
Hopefully,
thank you.
folks that have seen this, please share it with your friends. And I lived, there was a lot of, that was a pretty, there's a lot there to unpack. So I would suggest you listen to it a couple of times over, really especially if this may impact you, if you're thinking about a relationship, or you're an old, a more senior person and thinking about unwinding the relationship and what the consequences might be and the strategies that might help, and particularly to protect your children. And that's something that Jason is an important ally that we're happy to share. We know a little bit about it as well. So if you think you might wind up in this kind of situation, please don't hesitate to reach out, and we'd be very happy to give you our advice. So that, I guess that's it for another edition of Smarter Money Matters. It really does. I'm Jeff Camarda, Jason Porter of the Porter Law Firm. Thank you very much for coming.
Thank you for
having me. You have a
having
web
me.
address, Porter?
We do. Pickporter.com. And I was going to say, if I can, the information we provided today is general, and should anybody need more specific advice than that, consult an attorney you're comfortable with. Certainly reach out to me at pickporter.com. Would be happy to help.
Right, that's right. This is general, not legal advice today, regardless of his relationship with many fine judges. And Anna Wonderlick, our Super CFP. Thanks for watching. We'll see you next week. Thanks, guys.